Illinois Election Board keeps Trump on ballot, rejects challenge. Illinois' election board on Tuesday kept former President Donald Trump on the state's primary ballot a week before the U.S. Supreme Court hears arguments on whether the Republicans' role in the January 6, 2021 attack on the U.S. Capitol disqualifies him from the presidency. The board's unanimous ruling comes after its hearing officer, a retired judge and Republican, found that a preponderance of the evidence shows Trump is ineligible to run for president because he violated a constitutional ban on those who engaged in insurrection from holding office. But the hearing officer recommended the board let the courts make the ultimate decision. The 8-member board, composed of 4 Democrats and 4 Republicans, agreed with a recommendation from its lawyer to let Trump remain on the ballot by determining it didn't have the authority to determine whether he violated the U.S. Constitution. Trump's attorney urged the board not to get involved, contending the former president never engaged in insurrection, but that wasn't something it could determine. "We would recommend and urge the board to not wade into this," attorney Adam Merrill said. Trump cheered the decision in a post on his social media network, Truth Social. An attorney for the voters who objected to Trump's presence on the ballot said they'd appeal to Cook County Circuit Court. The issue will likely be decided at a higher court, with the U.S. Supreme Court scheduled next week to hear arguments in Trump's appeal of a Colorado ruling declaring him ineligible for the presidency in that state. The nation's highest court has never ruled on a case involving Section 3 of the 14th Amendment, which was adopted in 1868 to prevent former Confederates from returning to office after the Civil War, but has rarely been used since then. Some legal scholars say the post-Civil War clause applies to Trump for his role in trying to overturn the 2020 presidential election and encouraging his backers to storm the U.S. Capitol after he lost to Democrat Joe Biden. Dozens of cases have been filed around the country seeking to bar Trump from the presidency under Section 3. The Colorado case is the only one that succeeded in court. Most other courts and election officials have ducked the issue on similar grounds to Illinois, contending they don't have jurisdiction to rule on the obscure constitutional issue. Maine's Democratic Secretary of State also ruled that Trump violated the 14th Amendment and is no longer eligible for the White House, but her ruling is on hold until the Supreme Court issues a decision. Trump's critics argue he's disqualified by the plain language of Section 3, which forbids those who swore an oath to support the Constitution, then engaged in insurrection against it from holding office. They contend the former president is ineligible just as if he didn't meet the constitutional threshold of being at least 35 years old. The Illinois board members ducked the issue by concluding that, under state law, all they can do is assess whether the basic paperwork candidates fill out is true. The only way to remove Trump would be by concluding he made a false statement when he swore under oath in that paperwork that he was eligible for the office he sought.